providing with the letter, by the way, Your Lordship, he then receives for the first time a letter from the Secretary saying, by operation of law, you are no longer on the list. That's the first time he learns about it. He writes back to Parliament and said, well, I mean, the proper thing to have done is to ask me what my version is. It's in the public domain. Everyone knows. And I'm asking this court to take judicial notice. It's in the papers, as a matter of fact. We have annexed the affidavit in front of the electoral court where there's a clear dispute around the leadership of MK. The least rationally acting the Secretary should have done is, do you have a response to this? They can still make a determination, but surely after the fact that, well, after having consulted my client, having brought the letter to his attention, asking to respond, that does not happen. And all we're simply saying is, it will be of no utility to my client to say, yes, here's an interim date, but I will allow Mr. Zuma to remove him again, notwithstanding the fact that there's Part B and an appeal to the electoral court decision. Finally, I want to deal with the question of urgency on the preliminary points. The argument is that, well, why now? Well, now because Parliament made the decision just last week. That's why now. The cause of action, we can't have been here pre that determination by the Secretary of Parliament. He made that determination earlier in the week. Actually, I stand to be corrected on that point. It was, I think, 3 days ago that that decision was made. We can't have been here before that decision was made. Because again, there's this conflation and misdiagnosis and mischaracterization.
But what I need to engage with you about is, as far as I understand the papers, your client was aware of his expulsion, in inverted commas, from the party, rightfully or wrongfully, on the 25th of April. I don't see anything in the papers, unless you can direct me to that in the papers, as to what steps your client has taken in connection with addressing his allegation that that expulsion was unlawful.
Yes. So, it's a good question. The question of whether his expulsion is lawful or not, you can accept the question before you watch.
No, I understand that, but it is a factor which a court, I think, may or must take into consideration in considering the urgency of the matter. Are you in agreement?
Well, as a matter of principle.
So at least we agree on something.
Not so much in agreement.
All right. Okay.
Precisely because what you will see as an annexure to the papers is an explanation of what happened following that expulsion. My client says, I tried to reach out to Mr. Zuma to have a discussion about why we did not basis his expelling. That's what he says. He gives a media interview with one Mrs. Pamandla Boke, where he says, I am trying to resolve the issue internally with Mr. Zuma. I've been seeking a meeting with Mr. Zuma. I'm awaiting that before I take any action. Because you understand that if there was a Rule 41A, for example, the idea behind mediation, you do not burden the courts unnecessarily when you've got a tenor remedy. He says, that's what I seek to do. He then says, in response to that interview, which was in the public space, Ms. Dudu Samuel Zuma tweets, there will be no meeting or love back with Mr. Khumalo. At that point, then it becomes clear to him that there's nothing he can do either than to approach courts.
And when was that tweet sent?
That tweet was sent, please just find it for me. It would have been 2 weeks or a week before the Concord matter, which is of relevance. I'll just confirm the date of the tweet. It's JK5. It's JK5. Check JK5. I'll confirm it for you just momentarily, Your Lordship, but it would be JK5. And that was a couple of days before the Constitutional Court matter, which Mr. Khumalo wanted to involve himself in as well, as means of trying to resolve the issue with Mr. Zuma. I'll confirm the date momentarily. Perhaps it's of moment. I should be doing it now. But the claim is at paginated 58. 58. Where he says at paragraph 31, I further advise Mr. Koke that I intend to meet with Mr. Zuma in this regard, and in fact made many attempts to do so. To my dismay, Mr. Zuma's daughter, Ms. Duduzile Zuma Sambudla, publicly responded to my comments as follows. Just checked President Zuma's diary, and there's definitely no meeting scheduled with former member of MK, Jabulani Khumalo, tomorrow, and there's definitely no room for laugh back.
Do we have any for that?
I beg your pardon.
Do we have any time frame for that, when that happened?
That is what I'm asking client to just, or rather my junior, in front of the electoral court and the constitutional court as well. As soon as it does that, I'll confirm with you, Lordship. But the simple point is, he tried to exhaust that internal remedy, and there's no dispute around it, by the way. So there's no denial of that fact. And the tweet itself was attached, and I'm asking my junior to try harder in finding it and quicker, please. And what you will see is that a week after that, there's an application brought to the Constitutional Court. And Mr. Khumalo tries to vindicate his rights by being part of that process. I mean, of course, he was not heard ultimately. But 6 days later, he then brings the application to the electoral court on advice. And the idea was, to the extent the electoral court directs the IEC to restate my client as the president of Mkondo Sizwe, then again, problem solved. Because then he's back on the boat again. Whether that was good advice or not is besides the point. The question is, how did he act? When did he act? Did he act expeditiously? Did it take too long? And we're suggesting he exhausted, or at least attempted to exhaust the internal remedy. He sought recourse in the Constitutional Court. He sought recourse 6 days later at the Electoral Court. So it can't then be that he did not act with due urgency. What you'll find in the answering affidavit is the claim, and it's certainly in the judgment of the Electoral Court itself. It says, well, he knew about the forged letter on the date it was forged. But his very version the entire time is saying, I did not know of the forged letter. Why did he not know? Because the letter purporting to his resignation was not written by him. Neither was it sent by him. What is common cause fact is that it was not sent by him. It was rather after the IEC invites Mr. Khumalo to give a position as to whether he wants to resign as party leader and have Mr. Zuma as party leader. They write that email to him, copying Ms. Zuma Sambudla. He's not the one who responds. Ms. Zuma Sambudla responds and removes Mr. Khumalo from the list of people who will be receiving the response, which is his purported resignation. So he did not know about the letter until such time that the IEC put it in the public domain, that Mr. Zuma has been the party leader as of the 10th of April. To his shock and dismay, frankly, because he knows he did not give that version, or rather did not ask the IEC to act in that manner. I don't want to argue the matter, it's just for purposes of context, that Regulation 9 says only the party leader may effect a change to a party leader that is registered with the IEC. And then a letter comes, and it's common cause that is sent by Mr. Zuma Sambudla, not Mr. Khumalo. And in that email, it's common cause Mr. Khumalo was not copied. How then can it be argued that he knew as of that date? The point I simply seek to make is urgency kicks in as of knowledge of the problem. That's the totality of the submission I'm making with respect to your lordship. And I'm saying, as soon as he found out, he wrote a letter to the IEC dealing with the issue of internal remedies. Not only did he seek to engage Mr. Zuma, he wrote to the IEC saying, I did not write the letter. On what basis do you effect a change without confirming with me? Particularly because you yourselves know that the email came from Ms. Dudu Sambo. On what basis then do you take a version without at the very least calling me to confirm the contents of the letter? That's all he says. What's rational in those circumstances where you as the IEC say, I am effecting a change on the basis of letter I've received, not from the party leader, notwithstanding Regulation 9 saying it must come from the party leader. You get this letter from Ms. Zuma, and you do not call client to ask to confirm the contents. The point I'm making is, urgency kicked in as of knowledge on that date. I think then I've exhausted the preliminary issues. Let me deal with the substantive content of the application, if the court pleases. What you'll find in the founding affidavit is the substance of the application. And you'll find this, hold on. The basis for the urgent relief that is sought. He is claiming that I've got a prima facie right. And I think that's an important point to make, because what your lordship does not have to find is whether the right in fact and in law exists. That's not your determination to make, it's the determination perhaps for Part B. It is sufficient that, and as a matter of fact and common cause, he was on the candidate list of MK. Prima facie, then he's got that right to be a member of parliament. What is common cause is that he was a leader of MKP, registered as such with the IEC. Prima facie, he's got a right to lead MKP. This is not space to discuss the politics, as the court was invited to do in the electoral court. It's a simple question of law. Was he a party leader and registered as such with the IEC? The answer is yes. He's got a prima facie right in section 19(1) of the Constitution, which says you've got the right to form a political party and to campaign for it. He has formed a political party, and that has been common cause up until the dispute before the electoral court. That right is of no moment if then, as we'll argue in Part B, you just expelled without any process whatsoever. So prima facie has got that right, and it's being violated by Umkhonto weSizwe by expelling him without due process. So if you accept those rights, prima facie, then I submit it has established the first requirement of prima facie right. Are they being at peril, or have they in fact been violated? The answer is again yes. How do we know this? Because the secretary says to him, you're no longer on the list. So it's not even an apprehension of harm, it's one that has materialized. Secondly, he cannot campaign and act as a member of Umkhonto weSizwe as per section 19 because he's been expelled. Now there's this misnomer and misdiagnosis of issues by arguing that Ramagata is of effect and therefore he doesn't have standing before your lordship. Ramagata deals with an issue of a party failing to comply with its internal processes constitutionally. That's what Ramagata is about. That is Part B of this application. So if I am lax and I do not make that argument in Part B, of course, then I must fail. But what he's dealing with here is not a challenge to the processes of Umkhonto weSizwe in expelling him and having him removed. That's not the determination before your lordship. That is a Part B issue. All I need to show you is that he's got this prima facie right. Has it been violated? Yes, it has. in that he's no longer on the list. And he's saying it's not a right in a vacuum, it's of substance. The first sitting of Parliament is going to elect the leaders of two branches of government tomorrow. They're going to elect the president, they're going to elect the speaker. Surely, representing his constituency, he must be allowed to exercise his right in making that determination and voting. That's the immediate peril. So I've established the actual harm, and I'm also establishing that if he's not in the sitting tomorrow, he will not be able to exercise that right, and he can never remedy it at whatever point. And no amount of damages, whatever they may be, can undo that harm, because his constituency will not be represented in Parliament. Which then takes me to the crux of what this really is about, I submit, which is a balance of convenience question. Having regard to the submissions I've made, what is the balance of convenience? Who does it favor? I say with respect my client, Mr. Khumalo, because him sitting in Parliament tomorrow will be him representing his constituency. What potential harm is there for MK if he sits there? Forget the politics, forget the personal issues between Mr. Zuma and Mr. Khumalo, which I submit is the actual reason he's being removed. It has nothing to do with anything else. And I'm saying, what harm is there if Mr. Khumalo, who by the way is number one on that list, well, at least ought to be, because we know the Concord found that Mr. Zuma is not legible to be a member of Parliament. Mr. Khumalo was number 2. By default, then he moves to 1. So we're not talking about a backbencher, we're talking about an integral part of Umkhonto weSizwe. We can all have a debate, perhaps, on a sundowner about what effect and what numbers MK would have had if Mr. Khumalo was the leader. We can all have that debate. But we're dealing with a legal question here, and the legal question is, who was number 1 on the list? It's Mr. Khumalo, the founder. Now I'm saying, if you then appreciate that, you can appreciate the difficulty of him having a remedy later on in time, where it's declared that he's entitled to be a member of Parliament, but he will have missed out on all these important decisions. What harm is there to be suffered by Umkhonto weSizwe or Mr. Zuma for that matter, particularly because they themselves had put him on that list as number 2, not Mr. Khumalo himself, but the leadership, including Mr. Zuma. When I say leadership, because I'm pretty sure Mr. Masuku is going to take me up on that and say, you see, you've just called them leadership. I mean it in the political sense of how they refer to themselves. It's a fact of the matter that Mr. Zuma is influential within Umkhonto weSizwe. But the question still remains a legal one. Was Mr. Khumalo on that list? Yes. Was he number 1 on the list following the Concord judgment? Yes. Is there an important decision to be taken tomorrow? Yes. Does Mr. Khumalo have a constituency? Yes. Will it be prejudiced if it's not there? Yes. Will he get a remedy at a later stage? I cannot comprehend one that can undo him missing sitting in Parliament. So the balance of convenience I submit with respect to Lordship favors the granting of the prayers that are sought in the notice of motion. Well, I'm told to say there's no alternative remedy. Well, it is not one that is substantial. I mean, there could be a remedy, theoretically speaking, but the question is it substantial? Is it one that puts him in the same position would have been but for the decision of the Secretary of Parliament and Mr. Sihle Ngubane, whoever it may be? And the answer is no, you can't remedy that in due course. Unless your Lordship has got questions for me, I'll be the sum total of my submissions, and that I take and reply to confirm the date that your Lordship is looking for.
You would ask your junior, who I'm sure is being paid handsomely for his attendance, to let me have the date of the tweet.
Can you please find me the tweet, the one I attached to the papers? I'll confirm it and reply to it.
Thank you.
If you so inclined. Let's complete this.
Thank you. So, Mr. Masuku.
Madam, it's a bit interesting that Madam Friend starts off by saying what this case is not about. First indication is that the case is not about Mr. Khumalo's expulsion from the party, but that's exactly what this case is about. It's a very simple theory. He seeks to challenge that expulsion by way of Part B, over which there is no jurisdiction issue of this court then is activated. The lack of jurisdiction in relation to Part B is immediately triggered, because what my learned friend must do is firstly to undo the expulsion. That's what he seeks to do in paragraph in Part B. Once he has undone the expulsion, then we can talk. Right now, he is expelled. His client, or Mr. Khumalo, is expelled. That's the starting point. And in Part B, he seeks to undo that. Does this court have the jurisdiction to undo the expulsion of Mr. Khumalo? It doesn't, because that's not the case he's making here. He is not making the case that the expulsion of Mr. Khumalo was unlawful. The Sixth Court's declaration of that unlawfulness. What they seek to do is to ignore for this court to ignore the consequences of a decision taken by the party, which is the expulsion decision. And given that the expulsion decision is not before you can accept that only because he said Mr. Khumalo is not a member of MK because he was expelled, right? For him to come home, he must undo that expulsion. Because if he undoes the expulsion, then Parliament will not take the decision that they took in terms of Section 47, 47(3) of the Constitution. Parliament, the Secretary would not have taken, the consequences of that expulsion would not have been his removal from the parliamentary list.
So suppose a situation arose where a letter was written to the first and or second respondents to say, please remove the applicant from this list. And before that decision was taken in any way, a letter came from the applicant to say, look, please don't act on this letter because I'm going to challenge my expulsion from the party. What would then be the legal position of the first and second respondent?
Well, the legal position has to be based on what's before the decision makers. They can't take, firstly, there are no consequences for a letter saying, I am going to challenge. It's got to be a challenge. There
That's
are no
the point.
consequences for saying, I'm going to challenge.
That's the
challenge
point.
has to be there. And then you've got a legal problem when you have that challenge.
And I suppose that challenge, there would be a request for interdictory relief regarding.
Yes. So what Mr. Khumalo in this courtroom seeks to do is to bring a matter involving the letter of expulsion. If you see this Part B, he says he wants that letter of expulsion declared unconstitutional and unlawful and all that. That letter was not written in Cape Town. It was written, I'm not sure in Ghana, that's where it was written, if these facts are correct. If that is so, what he seeks to do is for this court to uplift a consequence of law. In other words, to say to the Secretary of Parliament that, or say something, we'll talk about this with the Secretary of Parliament for a moment, because there's no order directing the Secretary of Parliament to do anything. That's why they're probably not here, because there are no orders against them.
See, in paragraph 1 of Part B, a declaration is sought against the third respondent.
Yes. So in a way, it's
got nothing to do with the first and second respondent.
Yes. So and how I've reasoned around is to say, firstly, there is a letter of expulsion which is dated the 25th of April or the 26th of April, it appears as date, and there is a communication of that expulsion on the 26th. You'll see that in in a letter on page 70 of the papers. That's where expulsion from MK. That's from the Office of the Secretary General, and it's a comrade second volume. That's who the person comes from. Now, what he seeks to do is to protect the right that he has not perfected in claiming. In other words, he says, I've been expelled. The consequence of expulsion, and Marlene felt there's no difficulties accepting that, is that if he's expelled from the party, Section 47, Section 47.3 says a person loses membership of the National Assembly if that person ceases to be a member of the party that nominated that person as a member of the National Assembly.
So that's by operation of law.
That by operation of law. That's what it's about. So what you have here are facts that clearly against him. You've got a letter of expulsion from the party, which he says he wants to challenge in Part B, right? But that doesn't give him a right. The fact that he's to challenge that letter of expulsion doesn't give him a right. It triggers other problems, one of which is agency. Why on the eve of the convening of the National Assembly are we here? When his expulsion was as far back as 25th of April, for which we would have reasonably anticipated that his expulsion from the party would affect his membership in the list. The agency is not explained, and as set out in the answering affidavit, it's clear that you would have known as far back as the 26th or 25th of April when he was expelled, that the consequences of that expulsion would have been his loss of membership in the National Assembly. To tell us now that he brings an application to challenge the legal consequences of his expulsion in a court in Cape Town when he has not in fact brought an application for his expulsion in the proper court, is just wrong. So we would say that yes, the relief sought against someone, we're not sure who that person is that is sick, because we say that the upliftment of, if the court can only uplift the consequences of Section 47(3) if the applicant has been able to prove that he's not been expelled. The applicant is here saying, I have been expelled. I am challenging that expulsion, but is in the wrong court. Because this court has no jurisdiction to determine the question. And secondly, as against Parliament, there's nothing against Parliament that he could challenge. What the Secretary has simply done is clarify, simply to convey to him the consequences of his expulsion from the party. Now that doesn't trigger any agency of the nature that Madam Friend suggests it triggers. The agency is triggered, or the starting point for any application to restore his membership of the National Assembly is if he had gone to the court after he had been expelled and challenged his expulsion. And here it's very interesting because even if you look at Part B, which is hopelessly unimpressive. I mean, he wants a direct order that the letter of expulsion are unconstitutional and lawful and all. Could that point not be made in a paragraph in the appropriate court?
So you're saying that had the applicant approached a court to challenge his expulsion as a matter of urgency, in that application he could have asked for an order that pending the outcome of his challenge to his expulsion,
yes,
that the first and second respondent cannot remove him.
Yes. He would have said, no, not say first and second respondent cannot remove him. That the consequences of Section 47 of the
do not apply.
Are suspended.
Suspended.
Whether that's competent or not, that's a debate for another day. But that appears to me to be in the proper way to do it. The proper way to undo this onion that is trying to unpeel, he has to firstly peel off the letter of expulsion. He has not done it. He cannot claim to seriously claim that this is a matter for this court to determine. He's not asking this court to determine that question. He's very clear about it. Firstly, because he understands that this court has no jurisdiction to do it. If there was a case in KZN in which the pending case of Mr. Khumalo challenging his expulsion, or as your lordship puts it, could have come to this court and say there is a pending matter in the KZN that deals with this very question that has resulted in my expulsion from the National Assembly. Can a court give me a right for that matter to be determined first? But to bring on this, under this agency, when I was instructed last night, to bring this kind of matter under this kind of agency, not the way to do it. But this case is bad for many reasons.
So before we move on to that, Mr. Masuku, can I just ask you this? In paragraph 2 of part A, I suppose I should have asked your opponent, but it says directing the applicant be reinstated on the MKP parliamentary candidate list as number 1, pending part B application judgment. Okay, we've dealt with that argument. But then it says, and pending the electoral court judgment, including the appeals, if any. So what do you say, how is this application before me today in any way influenced by the judgment by the electoral court yesterday, taking into account that the relief that is sought in paragraph 2 has the words including the appeals, if any, and we've now been informed that an appeal is going to be launched?
Well, the case of the electoral court case puts paid to Mr. Khumalo's claim to membership of MK. Essentially, what the court does is, I'll find it now on the court says that Mr. Khumalo has no standing to challenge an expulsion because he's not a member. Right. So in a way, what the court does is it rejects Mr. Khumalo's saying.
And does that go to the prima facie right, which the applicant contends for in his founding papers?
It goes to the because you can only have a right if you are a member, but if your membership has been terminated and you haven't challenged it or in an appropriate courtroom, then of course you don't have a right to raise your hand and say, please give me some right. So I just want to emphasize, my Lord, perhaps to refer your Lordship to the paragraph 42 of the electoral court judgment, and there it deals with agency and condonation. You'll see that it's very meticulous in how it explains the fact that Mr. Khumalo just didn't act as agently as he seeks this court to act in order to assert what he contends is right. And if the matter was not urgent in April, when he was expelled, it's not as urgent now. You can't wait from April and then come on the eve of the convening of the National Assembly claiming the right he does not have. Because in order for him to show up in Parliament tomorrow, he must first prove that he's a member of the MK. Unless he hasn't done that, he can't claim membership. He cannot claim membership or claim to be a member a member who should be on the list of the MK. Then I just also want to refer to my vote counts versus the speaker. It's 2016 volume 1, SA 132. That's in paragraph 33. There, the court makes it very clear that our constitutional order places the key to elective office and executive power in the hands of political parties. Members of the National Assembly and provincial legislatures are not directly elected, nor is the president and the deputy president. The same applies to provincial and national executives. Under the current electoral system, it is political parties and parties alone that determine which persons are allocated to legislative bodies and to the executive. If you cease to be a member of that party, that nominated you lose your membership of that legislature. Right, and of course, the court goes on in paragraph 33 to say that compelling considerations led this court in Ramakatsa, which is a very good judgment to look at when one is looking at the nature of our electoral system or the centrality of political parties. And it says the judgment's key findings are that they are the veritable vehicles of the Constitution has chosen for facilitating and entrenching democracy, and that they are the indispensable conduits for the enjoyment of the right given under Section 19. So Mr. Khumalo cannot show you membership of this party. He cannot ask you to protect him from what's happening tomorrow. What you have right now is expulsion, his intention to do something about his expulsion. But if you look at his intention, it's in Part B in this court. And the question is, does this court have jurisdiction to deal with Part B? You're correct that this court doesn't have jurisdiction because the state of the Now that means you don't actually have anything on which to assist Mr. Khumalo, because the requirements for an entity of the nature of Mr. Khumalo wish to have is if he was here in court saying, I have prima facie membership because I've challenged the loss of membership in court. I'm going to establish that I am correctly on the list of the MK and I should be considered to be a member who should be sworn in tomorrow. My Lord, in our answer affidavit, we have seen from paragraph 7 the constitution appears to have and then one of the points on this issue of jurisdiction is that it's clear that what Mr. Khumalo seeks to do is to have a basis on which Section 40, the operation of Section 47.3 should be suspended. Right, so, but how does he do that? How can he, what must he establish in order for that suspension to take effect? He must come to this court, as I said earlier on, with an allegation that he is a member of the commission. But we know he is not, because you will see immediately publicly that he seeks membership and he seeks to be reinstated. On the issue of agency, I think we dealt with it in paragraph 10 to 30. Clearly, if his knowledge of when he was expelled, which is the real problem for him is this expulsion. He was expelled in April. He's here in court on the eve of the very short truncated papers, and he can't seriously claim that the trigger for this application was the letter of the National Assembly. He would have reasonably known as an aspirant member of the National Assembly what requirements of being a member are. He would have known about Section 47, as he knows about other sections, for example. of the Constitution, you would have definitely known that Section 47 says that once you lose your membership of party, in the party, you lose your place in the National Assembly. So he has not explained at all what he has been doing between April up until today. So today he brought in a reply after it means that he had to work, my little friend had to work until the hours of the morning trying to put together that reply affidavit. That's agent. I mean, someone has to be dying basically to attract your attention right now. And Mr. Khumalo is not in that position of agency to require the court's attention. And then we deal with the confidential relief. So my little friend says we must read, and I mean he's entitled to manage an application to say who exactly wants the relief against. But I can imagine that when Parliament, when members or the officials of Parliament were considering on how to deal with this case, they asked themselves a very important question. The first of which is what relief is being sought against us? There isn't. But they cannot seek any relief against the Speaker, for example, because the Speaker is not there. We don't have a Speaker. They cannot seek an order against the Secretary of Parliament for simply conveying consequences of Section 47. So it's not clear exactly how he hopes the relief as he has framed can ever be considered competent. And then then one deals with the requirements of an agency. You'd have seen, my lord, that when he claims irreparable harm, there's nothing irreparable about a member or a non-member, someone who's not a member of a political party, asking to be given a status he is not entitled to. So you can't claim to have any harm. There's no harm because there is no right that he's claiming because he's not a member of the party. But to the extent that he's able in the future to set aside the deceased's value, nothing stops. The same party that accepts his representations, if it goes through the party or if it gets through a court, or that court directing that he be reinstated as a member, nothing stops him from then writing to hopefully the Speaker at that time to say, I'm now a member in good standing, or the party itself forwarding his name as a member who should be a member of the National Assembly. So he can't claim to suffer irreparable harm if he doesn't get solely tomorrow in circumstances where he's not a member. Because certainly tomorrow, when he's not a member of the party, violates Section 47, I think it specifically says that's one once you lose the membership of the party, you lose the membership of the National Assembly. Balance of convenience, there's no, the sky will not fall for Mr. Khumalo if he's not solving tomorrow. There will not be a hurricane or there will not be anything particularly spectacular if Mr. Khumalo is not, except for obviously politics and the ethics of politics, which your Lordship has no concern about. There is absolutely no basis on which you can say the balance of convenience favors putting a non-member of a political party to be a member of the National Assembly. That can't be a good way of seeing the balance of convenience. This, I listened carefully to my little friend trying arguing the case I was involved in. And because my friend Mr. Dali was involved in it, I sort of know that most of the arguments he was making arguments issued, they should stay in that courtroom about how Mr. Khumalo would have known about this letter because he didn't know about the letter. But even that is not a good submission. If one considers that Mr. Khumalo himself has written to Mr. Zuma, if one looks at the communication Mr. Khumalo sent to Mr. Zuma, where he specifically said to Mr. Zuma, but you can't explain. Sorry, my lord, I actually had it here where Mr. Khumalo had written something to Mr. Zuma to say that yes, it's actually in the judgment, not in the affidavit, it's in the judgment. The judgment is on page 15 of that judgment, paragraph 52 and 53. Where Mr. Khumalo says removal of Mr. Zuma from the list of members of the parliament, I wish to write to you as the president of Mkondo Sizwe, it is to request the immediate removal of Mr. Zuma's name as the first of MK. Send this letter to the commission on 9 April, in which I stated that Mr. Zuma would be the face of the party. And then it provides a brief. Sorry, I'm probably not reading this correctly. Let's go to paragraph 52. It says, however, pointed out by counsel for the respondent, the Khumalo failed to take into account, to check the statement to his confidence regarding when and how he became aware of the interim decision. He attached a letter to his founding affidavit, marked JK8. He sent to Mr. Zuma on 5 May. So on 5 May, he sent a letter to Mr. Zuma, suspending him from MKP, pending disciplinary proceedings. On the same day, he addressed a letter to the commission attached to his founding affidavit, and then they quote the relevant portions. So this idea, even this looking of when exactly the tweet came in, it's clear that as far back as May or April, May, Mr. Khumalo already knew where he stood with the party. There is no basis on which he should be in this courtroom today seeking urgent relief of the gravity of the nature of relief he seeks is extreme, because it involves suspending the operation of a constitutional provision or provision in the Constitution. And for him to be able to do that, he needs more than just say, I want to do certain things, or I want to have the declaratory order. So when this case, my lord, especially after the judgment of the electoral court came in, this case should have been, it was a hopeless case, really a hopeless case. And in trying to save the applicant, Mr. Khumalo, from making, I'm not being kind to my friend, but I think I've got guides to represent, making embarrassing submissions of the nature that have been made. You'll see that in the answering affidavit, a request was made by reference to that case, the outcome of that case. You'll see it's MK4. MK4 is not paginated on my thing, but it's a letter which was written by the attorney for the third and fourth respondents' appearance, MK4, where they say, as you are no doubt aware, this morning the electoral court delivered what can only be described as a devastating and unprecedented adverse judgment dismissing the application lodged by your client, Jabulani Khumalo, against our client. Our client's Mkondo Sizwe and former President Zuma. The court even departed from its custom of awarding costs and mulcted Mr. Khumalo with punitive cost on the back of the court finding that he committed criminal offence of perjury. And I accept that the commission of perjury justified the punitive cost order. And then they invite Mr. Khumalo to withdraw the application, tender wasted cost on the attorney client stage, and attend to the removal of the to the road without the need of counsel appearing. Of course, what he gets is a one-liner saying without the instructions to withdraw. And that's simple. Now, this would be regarded as an abuse of the compassion court that justifies the punitive cost order of the nature that we would ask for. The preliminary questions that were set out in the answer affidavit were cogent enough for serious caution to be adopted. The issue of agency properly engaged should have resulted in the affidavit accepting that the starting period from which he used to explain the delay in bringing this application is not, as he says, is the removal, is the message he gets from Parliament, but it's at the time that people to know about his removal.
But surely there's some separation. If I'm with you on the issue of costs, there must be some separation, because when the applicant launched his application, the electoral court decision had not yet been delivered. So, but once the electoral court decision came to hand, and thereafter your instructing attorneys addressed a letter, from that moment on is your contention that attorney and client costs, the punitive costs order should follow.
Absolutely. Absolutely. Because it is an abuse of the court. I mean, I'm sure your lordship would have more cases to deal with that at the executive agency than a case of an applicant who wants to go to Parliament when he knows that he doesn't deserve to be in Parliament, because he's not a member of the political party. It's as simple as that. No membership of the party, no right to be in the National Assembly. It's a simple theory that escaped Mr. Khumalo when he brought this in. So we asked for that dismissed with costs on a escape.
Thank you, Mr. Musko. Are you in a position to reply, sir, or would you like Matt to stand down shortly? What would you like to do?
I would have preferred to proceed with the share my junior insisting that we take a break. Yes, let's do that.
So, do you follow your instructions from your junior? All right. The matter will stand down for 15 minutes, and then we'll proceed with your reply. And could you, in the interim, please try and get, for the purposes of good record, the signed deposed affidavit, and also the date of the tweet. Thank you.
And I will hence send to my senior for mistakes in my
Thank you. Court stands adjourned for 15 minutes.
if he chooses one pathway to achieve the same effect, which is his reinstatement as party president within the IEC. That is what he sought to do. And what we know from the decisions of Rock Trading, as well as, I'll list all of them and then give a principle. It's Rock Trading, as well as Hopkins versus Mendek Proprietary Limited. The principle there is, when dealing with the question of urgency, the court finds, and it's at paragraph 196 of Rock Trading versus Eagle Valley Granite. In my view, the delay in instituting proceedings is not on its own ground for refusing to disregard the matter urgent. A court is obliged to consider the circumstances of the case and explanation given. The important issue is whether, despite the delay, the applicant can or cannot be afforded substantial redress at a hearing in due course. A delay might be an indication that the matter is not urgent, as the applicant would want the court to believe. So it qualifies what it says, but the basic premise is this, and perhaps I should read this extract as well. And this is now the decision I made reference to earlier on, Mendek decision. The explanation is by no means now they're dealing with the question of explaining urgency. The court finds in paragraph 27, the explanation is by no means granular in detail. However, it is a cogent and, in my value judgment, suffices to cover the bulk of periods of the delay, albeit not every single aspect or day thereof. It is nevertheless accepted that, taking into account the length of the delay, the steps earnestly pursued by the applicant in attempting to effect service, the inexplicable conduct of Mr. Fesse was a subject matter that partly caused a delay in service. Again, the point is there is no burden on my client to, in granular detail, set out what he was doing at 2:07 on 28 April, and then the minute after, the day after. It's not that detailed, it's a value judgment. I am suggesting to your lordship that he has given an explanation of what he's done since he knew that Mr. Zuma will not give him an audience. He wrote to the IEC another internal remedy that is sought, having not come right with Mr. Zuma. He then says, I received a response from the IEC on the 7th. What does he do? He goes to the Con Court immediately, which sat on the 10th. The Con Court does not give him an audience. What does he do? On the 16th of May, he approaches the Electoral Court. Now, if he's given that explanation, with respect, there's no basis to argue that he was derelict in his conduct. Let me deal with the question of my junior is assisting me here with paginated page 72, which is a letter from Parliament, the Secretary of Parliament, where they say the only time we'll effect the change to Mr. Khumalo being back on the list is if the court orders so. We're not here out of our own volition. We're told by Parliament we should come here. And that is precisely what has happened. They say your only remedy lies with court. By the way, Parliament itself had said, well, we did not know, because the challenge to Parliament was, well, why didn't you send a letter to Mr. Khumalo? Why didn't you let him know about this letter from this Mr. Jabulani, whoever he may be? Why do you not grant him a right to reply? That is a prima facie right that has been violated. The Audi principle. He's not granted that. Parliament then responds and says, oh, we did not know about the urgent matter before the courts. But, well, we've made the decision now, but we'll abide the decision of court. That's the stance of the Secretary of Parliament. We'll not oppose the application, we'll abide the decision of the court. And we say, well, then that's precisely why we're here, because Parliament told us to come here if we want a remedy.
You see what What Parliament says on page 72, in the last paragraph of the first page, or the last, I only have the, it's only one page, the second last paragraph of the letter, it says preparations are being made for the first sitting of the 7th Democratic National Assembly, and we hope that the question around the membership of Mr. Khumalo is resolved by the court before that date. Now, I'm not in a position here as we sit to resolve the membership of Mr. Khumalo in and to the fourth respondent.
No, absolutely, Your Worship.
In and to the third respondent.
No, absolutely, but that's not what we're inviting you to do. If this court takes the position that Mr. Khumalo has all these prima facie rights and they cannot be remedied in due course, in the interim, put him back on the list. That's all we're asking of you.
So on that score, talk to me about, engage with me about this irreparable harm. The election of the Speaker of Parliament, is the voting for that not done, for want of a better word, en bloc by the political party concerned, by the various political parties concerned?
No, sorry, Lordship. I'm going to wait for you to...
No, that's the question.
Members of Parliament, and we know this from Kankla, from UDM, are individual members of Parliament. There is no concept of what a political party that has colors green, black and yellow would suggest. There is no individual consciousness. You vote along party lines. What UDM says, you swear an oath of office as a member of Parliament as an individual. You owe your allegiance, which is what the swearing in tomorrow will be about. You owe your allegiance to the Constitution. You make a decision on the basis of you being sworn in as an individual member of Parliament. Which is why, and it's a matter we litigated here in Cape Town on behalf of the EFF, that the Speaker would en masse say, EFF members leave, you're being disruptive. There was a challenge to that decision by the Speaker of treating people as a bloc because they represent their parties, granted they are deployed by their parties, if you will. But their function is to act independent of their parties on individual convictions, owing their first obligation to the Constitution, not the interest of the party. The point I simply seek to make
So the irreparable harm will relate possibly to one vote?
Well, insofar as Mr. Khumalo is concerned, it could well be inconsequential. I accept the point. It could well be inconsequential whether it's there or not. I'm prepared to make that concession. But the bottom line still remains.
So then, if you, and I'm not saying you are conceding that point, but if you are prepared to engage with me regarding the validity of that point, then the next question is, let's just suppose, for the purposes of my debate with you, that in sometime in the future, Mr. Khumalo is successful and his expulsion is set aside from the third respondent. Nothing prevents him from then being put forward by the third respondent and being sworn in as a member of Parliament. Am I right?
Absolutely. You are, Your Worship. But the point we make is we take it a step further. It's not him being Parliament for the sake of being Parliament. It's the deprivation of the right to engage in such an important debate tomorrow.
But I understand that. I'm with you there. But the question is it irreparable?
It's irreparable in the sense that he'll never cast a vote for the president, certainly not with this administration. It's irreparable in the sense that he can't vote for the
Well,
Speaker,
maybe not in the seventh sitting of our democratic Parliament, but I understand. Thank you.
That's not the entirety of the business of Parliament. There's more things to be done by Parliament, by members of Parliament. We just make a point about voting for the president for the sake of illustration. But it's not just confined to that. So for as long as it's not in Parliament, it's going to miss every other aspect of the debate. Assume, for argument's sake, the matter is eventually resolved by the Court 3 years from now. Now you can appreciate the damage and the extent of it. And he's not sitting in Parliament for his own sake. He's definitely receiving the salary personally, but he represents a constituency. And if it is found later on that he was entitled to be there, he would not have represented his constituency for as long as the matter has not been finally resolved 3, 4, 5 years later even. So the point we simply seek to make is it's not just about the election of the president, it's the extent to which he will be absent from Parliament pending all these appeals. We're saying it's a placeholder. And if the proposition is, well, his participation there is insignificant, is 1 of 400, well, the inverse could be said about Mkhonto Wesizwe and Mr. Zuma, who are opposing this application, that, well, similarly, his presence there is inconsequential. It must cut both ways. In the same way it doesn't matter for him, well, it shouldn't matter for Mkhonto Wesizwe as well. And that's the submission we make. If it's so insignificant, then on the balance of convenience, then why is he not in Parliament? Particularly, the whole point to an interim entity, Lordship, is to vindicate what may come later. That's the whole point. And we say if there's potential, he's got a prima facie right, we've suggested to you that Mr. Zuma, unilaterally, without any process, you will have regard to item 25 of the MKP Constitution. It says, one, you must receive a notice before you're expelled. You must be given Audi to defend yourself. Even when that happens, then there must be an appeal. This suggestion that, well, why didn't you challenge the expulsion? Because it's never received a notice. What is it challenging? Section 25 of MKP Constitution sets up that process. There is no debate before your Lordship suggesting that such a notice was sent. It's common cause it was not. And we are saying, in all likelihood, I make the submission, no court will say this was a fair process in compliance with Regulation 25 of MKP Constitution. And if that is the case, then he should not have been removed as a member of Parliament. Because his expulsion, which is the basis for his removal, was unlawful. It's common cause that he never received such a notice in terms of Section 25 of the Constitution. On what basis, then, can you find that he was properly expelled? Mr. Zuma has not suggested that we sent such a notice. Mr. Zuma does not suggest that we gave him Audi. Mr. Zuma does not suggest that we gave him a right to appeal. None of that has happened. On what basis, then, can you possibly say his expulsion was lawful? And if you take that judicial peek, then you can see how, if eventually comes right at a later stage with his expulsion, the damage that will be caused by him being out of Parliament for all that time. That is why we're in front of your Lordship today. On the point, your Lordship, you're making earlier on that it's about the membership of Mr. Khumalo. It's not membership in a party, because if you have regard to the last sentence at page 72, Parliament explains what they meant by the reference you've given me on the same page. They say, meantime, the administration of Parliament must follow the legal prescripts pertaining to the membership of the Assembly, not of the party. So what they're inviting us to do is we must sort out the question of membership in Parliament in front of your Lordship. And then they say you abide with the decision of this court to the extent that you're saying there must be this interim order putting Mr. Khumalo back pending the appeal processes. So it's not a question of membership within the party that Parliament is talking about, it's membership of the Assembly. Your Lordship also had a discussion with the legal representative for Mr. Zuma and Mkhonto Wesizwe, and the discussion was around clause 3, prayer 3 rather. The prohibition and the interdict there is not just to Mr. Zuma and Mkhonto Wesizwe, but anyone else. That's what the prayer says. So the interdict and the prohibition doesn't just relate to Mr. Zuma or Mkhonto Wesizwe, but anyone else. By extension, the Secretary of Parliament, because ultimately he's the one who confirmed the position as he reads it. In any event, of course we're in the right court, because the Secretary of Parliament, or at least their office, is within this geographical jurisdiction. And there's a point taken to the effect that we don't have a speaker. Well, that's not to our knowledge. As you understand it, there's an acting speaker. But even if there's no actual warm body in that office, the respondent cited is not an individual, but the office. So it's of no moment that there's no warm body occupying that office, because ultimately it's not in his personal capacity that we seek these orders. It's in that office that we seek these orders. If I could turn my back to Lord Sheikh, I'm
certainly.
Is this their answer? My junior tells me at paragraph 35, which is Mr. Zuma and Mkondo Wesizwe's answering to David. Mr. Zuma and Mkondo Wesizwe themselves say the removal by the second respondent. They themselves say that. Which is why then it comes as a surprise to us that they take the point that the secretary had nothing to do with this, is improperly cited. They themselves say at 35, it is important to reiterate that at the time of his refusal by the second respondent, who was the second respondent, the Secretary of the National Assembly. That then implicates the relevance of the secretary. Because in their own version, it's the secretary that removed him. How then does he not have a material interest in the matter? And if we're good on that score, how then does this court not have jurisdiction? An argument is made along the lines of in the wrong court for Part B. Well, we could well make that determination later on. We could well move the matter to KZN or wherever else you'd have us. Johannesburg, wherever it may be. That is irrelevant. Why are we arguing jurisdiction of Part B here? It could well be a sound argument when Part B is eventually heard by this court, that we're in the wrong court. Let's debate the merits and the demerits of that at that stage. What is indisputable is that we're in front of a proper court for purposes of Part A. I respectfully submit. I'll deal with three last issues, Your Lordship, and I'll invite the bench to ask me questions to the extent they have any. The claim is that the letter by the Secretary is a mere clerical function. With respect, it's not. Because, as Hoekstra would tell us, if you make a decision that has an external legal effect, that is not a clerical decision. It's a decision for purposes of parja and certainly for purposes of legality. Because he is not changing the typo of a name. He's not putting someone in list 2 when, well, even that is substantive. The point I simply seek to make is, as a consequence of that letter, Mr. Khumalo is no longer in Parliament. That can't be clerical with respect. It can't be. It's a substantive change that removes Mr. Khumalo from Parliament. But for the letter of the Secretary, Mr. Khumalo would have been in Parliament. It is a consequence of that letter, whether it's an ex lege issue or not, and is confirming a legal position. The submission is a humble one, which is simply that, but for that letter, Mr. Khumalo would have been in Parliament tomorrow. It can't then, with respect, be just a clerical function that he exercised. He confirmed a position in law. A confirmation of a position in law can't, on any construction, be said to be clerical. Just peg it for me and remind me when I'm done. My apologies, Your Lordship. I'm skipping through my notes because I think I've dealt with some of these aspects. I do not want to belabor the point and detain the court unnecessarily. If you could just bear with me, Your Lordship. Again, we've made the point that the question before the electoral court has nothing to do with Part A and Part B here, so it can't possibly have any bearing, particularly because Mr. Khumalo, at least, he caused his legal representatives to write to the electoral court informing them of his intention to appeal that decision. And with respect to your lordship, every submission that was made on the merits and the demerits of Part B with respect can't be of moment here. The confines of the debate should simply be, are we here at the right time? Question of urgency, that's what you have to decide. You have to decide whether you've got jurisdiction to hear the matter. You say, of course you do, because on Mr. Zuma's own version, the decision to remove Mr. Khumalo was by the Secretary on their own version. So of course then, your jurisdiction is triggered. As to whether we're right or wrong on Part B in terms of jurisdiction, you reserve that for that court. I mean, because then while we're there, if you can make that determination yourself now, we're not inviting you to do that. And I've made the point around when you can effect a change to a parliamentary list. Schedule 19, Schedule 1A, Item 19 of the Electoral Act provides that you can only amend within the first 12 months at the end of the list. You certainly can't remove the number one candidate. Whether there is merit to the argument or not, again, your lordship, you don't have to determine now. All Mr. Khumalo is suggesting is that there is that prima facie right on the cold reading of that provision. And if you accept there is that prima facie right, you must accept it's a peril now. In fact, it has been violated, if you will, because now he's removed from that list. That's all you have to decide. Whether there's merit to it or not, it's sufficient that there's that prima facie right and there's that prima facie argument. I think that's the sum total of my submissions. If again you can turn my back to court and see if there are other submissions I need to make. I'm going to go on a limb here and run the risk of regretting it later. I'm just going to read what I'm told to read. I don't even know what the submission is. It's the decision of Shunmugan and another. It's paragraph 15 of our heads of argument. Have we handed up our heads of argument? Not yet. Okay. It's a decision of Shunmugan and others versus Newcastle Local Municipality and others. At paragraph 42 of that decision, it says, I therefore approach the matter on the basis that the expulsion of the councillors was no different from the expulsion of a member of any voluntary association. In my opinion, a member of a voluntary association organization such as political party who has been expelled and who both contends the expulsion was unlawful and wishes to enforce his or her membership rights must, if the organization does not concede the unlawfulness of the expulsion, take steps to have the expulsion reviewed and set aside. Is your point that we've done that in Part B? Okay. And I've already dealt with the question of Ramagaza. Ramagaza has no bearing in this matter for a nuanced but very crucial point. The challenge there and the basis of the principle that came from Ramagaza is violation of the constitution of a political party. That is not before your lordship. If I have to make that submission at Part B, which I must, I'll raise that point then. So you can't argue that someone lacks loci standi on the basis of a principle that has no application here. It's a different question altogether. He's here to vindicate his individual right, which we've argued he has established at least at the face of it. And your lordship, I think I'm getting an indication that I am done, unless your lordship has got questions for me. That will be the sum total of our submissions. Let's proceed.
Sorry, Mr. Masuku, you want another bite at the cherry?
My little friend makes new arguments, which I'm entitled to respond to.
Yes.
But also, because I raised preliminary objections, I'm entitled to respond to preliminary objections. The first question, the reference to the Electoral Act, Schedule 1A, is a new argument. It's a hopelessly unhelpful argument. Because it relates to how political party can shift or can change members and replace members that have moved or not. But it's a hopelessly unhelpful argument. I don't even know why my friend would want to raise that. The second one is that there is no right to elect a president. There is no right. You cannot come to court on an urgent basis to say, oh yeah, no, I'm not prejudiced entirely, because if I'm reinstated later as a member of the National Assembly, I can participate in his legislative activities. But this one issue I was involved in, which was the election of the president, I am prejudiced by that. There is no right that a non-member of Parliament has to the election of the president. My little friend keeps making the same mistake of trying to sneak in the arguments about Mr. Zuma. This is also quite unbelievably prejudicial, because he says Mr. Zuma unilaterally, without a reference to law, removed Mr. Khumalo. And he refers to Section Clause 15. I mean, what must he do with that with respect to minority? He's not asking you to set aside Mr. Zuma's decision. He specifically says he's not doing that. So what is that submission supposed to result in? That reference to Mr. Zuma being no debate, there was no notice, and all that. I mean, that is a very unhelpful response, because we know he doesn't want you, and he cannot ask you to certificate on the merits of the expulsion. He says himself. But what he misses, what my little friend for the applicant misses, is that there is a legal reality of his expulsion. That's a legal reality. You can't wish it away. He wants you to wish it away, but it cannot be wished away, because it's a reality that exists right now before your lordship. There's clear evidence that he is not a member of MK. He's challenging it. Now, what he then wants you to do is to suspend the operation of law, the constitutional provision, section 47(3), so that he has this opportunity to go and challenge his membership. But the prejudice there is incredible, because what in this section is Part B is not successful, and it's been gallivanting in National Assembly electing a president whom he wants to elect and doing all sorts of legislative functions. He has checked the prejudice that would occur if he is not successful in his Part B. So when you conduct a balancing exercise of the competing rights that are engaged in this decision.
So you're saying the irreparable harm will be more prevalent in connection with the third and fourth respondent?
Yes, absolutely. Because firstly, they are represented by non-member. MK will be represented, will have in its National Assembly a person who is not a member. And by the look of things, we can see why he should not be a member of the third respondent. By the look of things, there is a breakdown of relationship that we will not ask to resolve that issue. But the prejudice to MK to have somebody whom they've expelled as a member representing there is highly prejudicial. But also it's prejudicial to the integrity of the institution itself. Because the institution is told only members who are only if you are a member of a political party that elected you are you entitled to membership. Section 47 sets out the law, and my little friend emphasizes it appears he doesn't like the word clerical. When I say the secretary performs a clerical, let's take it to his level. Even if he was exercising more than just a clerical error, conveying a legal position, that is the legal position. He has not contested that legal position is incorrect. He accepts that the legal position set out by Section 47(3) is that if you're not a member of the party, you can't be a member of the National Assembly of that party. Right? If you're not a party, you can't be a member of the National Assembly. He accepts that. It's a matter of law. Someone has to convey that. Someone has to sit down and say to him, "You are not a member of the party. You're not coming to we're not buying the ticket, we're not getting the accommodation to come to the National Assembly. Someone has to write. It doesn't take it's not an administrative or I mean, it's not a high level job, let's put it that way. Once it's established that Section 47 established a position of law that binds the national legislature, that's what the lordship is effective. That's what my learned friend's life also must be effective. If he's not a member of a political party, he must not come here and ask to be installed as a member of a national assembly when he has not removed that aspect of his membership. So it's unhelpful to keep making references to. I mean, it's really not worth what we're about here. Mr. Zuma's right or wrong is not what your lordship should do. And I know got upset about when I was in Durban, and the judge said to me, "It's also forget that there are cameras." So I'll try and not forget that for a moment and just get on with the job. The final issue is really about how my little friend just gave evidence from the bench, from the bar. Jim and I are experienced enough to know that you don't do that. When you are dealing with evidence of agency, you can't start telling us about the 28th of April, the 5th of May, the 10th of May, the 16th of May, the 9th of June. I mean, we can talk about the 9th of June because we know that's when the decision, the letter from the Secretary of Parliament came through. But all this is not his. When he was saying all these things, I went to the following affidavit, which is on page 22, from paragraph 60 right up to paragraph 76. This narrative he was giving about what Mr. Khumalo did and did not do on this particular case, it's not there. And that's not how we, if he had given us a baseline of what he did from the time he was expelled, this is what he did, and this is what he did, we would have it here. It's not there on this point of agency. And so this is getting evidence from the bar. It's not. I know he's been involved in this case much longer than I have, but mercifully he writes and then he talks. And then he remembers that he gets a memory from his involvement in different cases, and so he's able to articulate some of the facts that he has not put on paper. But so my lord would insist that this is an application that should not change the lordship more than should be dismissed.
Thank you. Thank you for your arguments in this matter. I have some other urgent matters as well. So I'm going to just stand the matter down. I'm going to consider it a bit further, and I will issue an order in connection with this matter at 2:15.
If I may, Your Lordship, I just want to respond to one point, if I may. I'm accused of making submissions and giving evidence from the bar. What you see, Your Lordship, is we've attached an affidavit before the electoral court as well as the Crown Court explaining what had happened, how it got to where we are. It's not in the body of the founding affidavit before this court, but it's annexed, and we specifically ask that it be read as incorporated. So including the argument around why am I talking about Mr. Zuma? Well, I'm talking about Mr. Zuma because you have to take a judicial peek of the prospects of my client's success before you can grant an interim order. And we're simply saying, if you look at the fact that, again, it's there in the affidavits that he was not sent a notice, it's never been contested in any court, in all likelihood, his expulsion will be reversed as a court basis.
No, that's also wrong. My little friend is not correcting anything, he's making it worse for himself. Because attaches only found in affidavit. There was an answer in affidavit to those found to those papers. There were answer in affidavits. They are not there. And if you want to be balanced, put the answer in the found in paper, put the answer in affidavits, so you get a full picture of what we're talking about. It's unhelpful for us to argue this.
Thank you. We'll make an order at 2:15.
As per cases.
Court stands adjourned.
They didn't deal with us. They did. Yeah, but see, I don't know there. So maybe you could say that. Okay, so what are we doing?
Uzobukwa na 230?
Yeah.
15. 15 or 50. 250 or 215. 250. Okay.
Wow.
Okay. What